So good morning, everybody, and welcome to day 2 of the Managing IP International Patent Forum. My name's Ed Connellan, and I'm Managing Editor of Managing IP, and I'll be your chair again for today. Yesterday, we heard about a whole range of topics, including COVID, AI, and international enforcement. And today we have an equally exciting lineup. But before we get started with the virtual sessions today, I would just like to once again stress that it is your participation that matters most. Swapcard, the platform that we're using today, is a great networking platform, allowing you to set up meetings for one-to-one video chats or to simply chat with one another. For those of you who are unable to join us yesterday, on the attendees tab, your top matches based on your interests will be shown first. You just need to click on a person's profile to suggest a meeting. Meeting requests and notifications will then pop up in the speech bubble at the top right of your screen. You can also see the full schedule for this event on the agenda section, which you'll find at the top of your page. I would also like to thank all of our sponsors once again, without whom this virtual event would not be possible. Today, you will also be able to provide instant feedback on each session by taking part in the poll, which will appear on the right-hand side of the video player. Please take some time to do this because your feedback helps us to tailor future events. So now let's kick off with our first session, during which you will be able to submit your questions to the panelists during using the Q&A tab on the right-hand side of the video player. Our moderator today is my colleague Charlotte Kilpatrick, who's a reporter at Managing IP. She'll be leading the first panel today, which is looking at the impact of COVID on international IP enforcement and protection. Charlotte will be joined by Özge, Atılgan Karakulak, a partner at Gun & Partners in Turkey, and Pravin Anand, a partner at Anand & Anand in India. So over to you, Charlotte.
Hello, thank you, Ed, and welcome everybody to this virtual forum. I really do hope that next year we're all in person and have a lot more fun at the drinks counter. Anyway, good morning. I would like to introduce my two guests. I have Özge and Pravin. Hello, guys. Good morning.
Good morning.
Good morning. Can we start? Can you guys just give a brief introduction of yourselves for everybody, who you are and what you do?
Sure. Özge Atılgan Karakulak. I'm partner with Gun & Partners. I practice in patent litigation and life science practice group, and I've been with the firm for over 15 years now.
Cool. And Pravin?
And I'm Pravin Anand, managing partner of Anand & Anand, and I've been in practice now for 40 years, and all I know in life is intellectual property.
Oh, God. Well, this is going to be a really fun conference, and good. We get to hear everything you know about life. Excellent. Özge, can we start with you?
Sure. So, putting my slides up. Can you see it now? Oops.
Yes.
Sorry, it's the end of the slide. Okay. So, good morning, everyone, once again. I'm very happy to join you today and speak at this conference. I think the first time I spoke at this conference was 2014, and this conference is held every year around the same time. So it's nice to see that at least some of our habits continue under these circumstances. So very happy to be here. Today I speak about 3-4 important points which reflect the patent enforcement environment in Turkey past COVID-19. First of all, just a quick 2 slides about an overview of how the enforcement environment looks in Turkey, small tips on the rules and the practice. So there's patent protection for 20 years, pharmaceuticals since 1999. Turkey is a member of EPC. This is frequently asked, but yeah, it's a member of EPC, also PCT and TRIPS. No SPC in Turkey. There is Bolar exemption, and there are specialized IP courts. They're specialized in all IP areas, not specifically to patents. And IP judges do not have any technical background. The experts are appointed from independent panels by the courts, and their reports play a dominant role as they help the non-technical judges in understanding the merits of the case. No criminal sanctions. The first instance proceedings for patent infringement or validity cases is around a year and a half, and twofold appeal proceedings each may take around 1 to 1.5 years. We can say that IP law in Turkey is closely aligned with the EU law and international norms, but enforcement has some shortcomings, and some of the examples will be discussed here. So let's come to how COVID-19 affected the patent cases. I can say that we have not experienced a major delay in proceedings due to COVID-19. Of course, in the first months, March and April, we had some postponements in oral hearings and slight delays in getting interim decisions by the IP courts. But IP courts generally functioned, continued their functions, and most importantly, preliminary injunction requests were heard as in, let's say, usual times. The major delay actually in patent cases continued to be the two-layer appeal system started since 2016. So the regional district courts were introduced with the hope to reduce and lighten the workload of the appeals courts. But in reality, we can say that the small claims, for the small claims, the procedure gained speed. But for patent cases, this is not the case. The timelines seems to be further prolonged due to this two-layer system, which of course increases the importance of PI orders, which in principle stays in effect during the appeal stages. Last year, we've seen a major increase in patent cases filed against the products given an early market access within the named patient program of the Medicines Agency. So due to the delays in GMP inspections, there's local GMP inspection requirements for pharmaceuticals. So due to delays in GMP inspections, increased pressure on lowering pharmaceutical prices and delays in marketing authorizations, we see an increase in supply of MPP, named patient products, by the government. This is actually an exceptional way of supply. These products are not registered in Turkey. They are purchased from abroad with higher prices compared to the authorized and registered products. So the government policy to control the budget for named patient program products led the payer Social Security Institute, the reimbursement authority, to seek alternative generic products, which may not have an FDA or EMA approval. There is a scheme called PIC. So Turkey is party to this system. So if a product is authorized and launched in one of PIC countries, then the product can be purchased. There is no mechanism to prevent supply of infringing products. The Medicines Agency and the Social Security Institute expect the patent infringement issue to be dealt with and resolved before IP courts among the parties. However, the difficulty is that the actual importer of these products is most of the time the reimbursement authority, the payer. The foreign supplier who is shipping the product to Turkey under MPP, and the Turkish partner, if any such company is involved, in the supply procedure or in the bidding process to the reimbursement authority is kept confidential. So there's no publicly available data that you can track the purchase of these products and find out the alleged infringers. And the patent owners hesitate to bring actions against the reimbursement authority as the importer. So this creates a lot of hurdle in the enforcement in this area. Another important aspect of this program is parallel imports. Actually, the parallel import in pharmaceutical sector is not an issue for registered products, since only the MA holder can clear products from the customs. But this situation is different in MPP. There is no marketing authorization, so the reimbursement authority, or sometimes the pharmacist union, are authorized, the only authorized institutions to clear products from the customs. So these products, the parallel imported products, can be purchased by the reimbursement authority. So this created a parallel import issue in the pharmaceutical sector, of course, limited to MPP products. I wanted to, share this point as it is important, but still, the main problem is more on the generic products, as they are the main cheaper alternatives. So the lack of knowledge about the alleged infringers bring hurdles in enforcing patents in this area. In one of the case examples, one of the IP courts issued a preliminary injunction on the product itself, irrespective of who was the infringer. So the product was prevented to be supplied by the government. Although it seems like a good improvement and a success, because after PI is granted, there is a mandatory requirement to file a full trial case, infringement action against the infringer. Otherwise, the PI is automatically lifted. So there's still an important need to know who the patent owner will sue in the infringement action. So we will see how this issue will evolve, and hopefully authorities will bring any transparency to this area. There's also a compulsory licenses aspect to it. When the compulsory licensing provisions were discussed during the enactment of the IP law, these MPP products were also discussed along the lines with, increased budget burden in terms of MPP products and whether compulsory licensing would be issued. There's not a major change in the IP law, but for the first time, we've seen the government claimed insufficient use argument, insufficient use of the invention / public health need argument in relation to a patented MPP product. So the compulsory licensing was not granted. There has not been a case. And I must note that there has never been a compulsory licensing issued in the pharmaceutical sector. But this threat actually provided the patent owner to lower the prices for this MPP product in order to continue supply the product in Turkey. So compulsory licensing has become an agenda in this MPP scheme, and we will yet to see how things will evolve in this area as well. When it comes to registered authorized products, the Medicines Agency continue to not provide any information about the applicants of generics. So the the generic application, when it is filed, the status, who filed this application is unknown for the patent holders. It used to be provided upon an information request by the patent holders, and the Medicines Agency would provide this information. But the Medicines Agency has changed this practice and just publish a list showing the number of pending applications only, but as numbers. So you would say for specific, you would see that for specific PI, there are 2 pending MAs, 3 pending MAs, MA applications for generics. And of course, this may include different forms of the same product or another originator company's product for the same INN. So still this area is very gray for the patent owners. So the patent owners can publicly learn about a generic once marketing authorization is granted, which gives an extremely short period of time to file a preliminary injunction against an allegedly infringing generic. So due to Bolar exemption, some IP courts does not accept infringement claims until the sales permission. On the right side of the chart, you will see after MA, there's sales permission. So some courts does not hear any PI request or infringement claims before sales permission is granted, and the price approval is included to this process. And even some courts does not allow applications unless the product is reimbursed or launched. So this issue continues to be a difficulty in finding the right strategy to timely and efficiently enforce the patent in the pharmaceutical area. And finally, an important development was that one of the IP courts recently heard an indirect infringement claim and granted a preliminary injunction against an indirect infringer. So this seems to be the first time such a PI is granted in the indirect infringement area. So the patents here disclosed a combination of API X and API Y, and claim did not require presence of X and Y in the same pharmaceutical form. So the defendant commercialized the API X only. However, the product was prescribed and given to a patient together with a product with API Y ingredients. The fact that the patient population for the API X was minimal was widely discussed. Also, the meaning of product readily available in the market, as we see in several other international, let's say, country jurisdictions laws, like in UK and Germany. So the meaning of this concept was widely discussed among the parties. At the end, the court was convinced to inquire this patient population information from the reimbursement authority, as the reimbursement authority covers almost the whole population, and the reimbursement authority gathered information from the hospitals and confirmed to the court that 80% of the defendant's product was prescribed in combination with API Y, although separately. So at the end, the court issued a preliminary injunction against the defendant. The PI was lifted at a later stage for other reasons. So the case is still pending, but the case has been the first example of such a preliminary injunction in Turkey in terms of indirect use of the invention. So this is all I have to say today. Thanks for listening to me, and if you have any questions, I'm happy to answer.
Great, thank you, Özge. That sounds like a very nuanced, intricate case. So was it because, sorry, before we go to Praveen, was it because it was only 80% of the population that they ruled the infringement? If it had been less of the patient population, do you think they would have gotten the PI? Was that the thing?
I think that was an indication that the purpose and the intention of the defendant was actually to cover the whole market, the combined X plus Y market. That was the indication. And that was a good proof that the patent owner could collect through the reimbursement authority.
That's very
Otherwise, the difficulty in these kind of cases is the evidence, how to prove, you know, the intention of the defendant was that, but this information helped the patent owner.
Okay, very interesting. Great. Well, thank you so much. We are now going to move on to Praveen. I'm just going to remind those who are watching, if you have any questions, by all means, shoot them over and I will pass them to our panelists. Okay, Praveen, everything you know about patent law and life. Here we go. Oh, I think you're still on mute.
Thank you, Charlotte.
Yeah.
Özge, Natalie, Ed, and the full support team at MIP, all my colleagues and friends in the IP fraternity who may be watching. Hope all of you are fine. I further hope to meet some of you later this year. I must say that the first door to freedom has opened as the vaccination program in India has started in a way, in a fairly big way. And so we are hopeful that things will kind of settle down and normalize pretty soon. And we will be back to meeting each other at conferences later this year. I would like to start with my slides. Can those be put up? Yes.
Almost.
I can't see them. Yes, let's start from the first slide, yes. So first, let me take a flashback. I'm going to take the last 10 years, 2010 to 2020. And this has been a period where we've had very positive IP developments in the patent world. And I just take some of them. To start with, coartimate injunctions were granted in a very big way. Earlier, 1996, there was the France Zever case, which had virtually said that in patent cases, no interim injunctions ought to be granted. And then the position changed, and in Bristol-Myers Squibb versus Hetero, 2009, 13 years later, ex parte injunctions started getting granted, and they were coartimate in the sense of you would go to the DCGI and get hold of the, you would move applications under RTI, under the Right to Information Act. The DCGI would inform you that the such and such party has applied for marketing approval. Then based on that...
Praveen, can you go full screen with your slides? It's just that I think for most of us, we can't see the small writing. I am peering in and my old lady eyes can't see it. Yes, great. Thank you. Keep going. You're great.
Is that better? Yes. So I was talking about how coartimate actions started getting granted solely on the basis that there was a reasonable apprehension that somebody was likely to launch a particular drug, either because the RTI, Right to Information Act, provided information as to the pendency of an application before the drug authorities, or because there was a website of, let's say, Trade India, which had an advertisement saying product in the pipeline, or at some seminar, a PowerPoint presentation was given by someone which spoke about a possible launch, or somebody consulted with a doctor, and the doctor provided evidence that such and such company is likely to launch a product. Only solely on the basis of such apprehension, we were able to go to court from 2009 onwards, and despite the law which prevailed from the France Zever case in 1996 onwards, that no interim injunctions ought to be granted in IP cases, the position changed. And in the last 10 years, literally hundreds of cases, interim injunctions were granted in intellectual property cases. So that's one very, very major change that came about. Second, post-trial cases would never conclude. And in the period from 1947, when India became independent, to 2000 and maybe 2010, there were no cases which had actually concluded after recordal of evidence in a patent infringement case, except there was one in 1966 when Blanco White had come to India to argue a matter before the Bombay High Court. But other than that, there were no cases. And so it was wonderful to have the first two cases after 46 years of the new act, Merck versus Glenmark and Roche versus Cipla, which were decreed in favor of the plaintiff, one related to sitagliptin, the anti-diabetes drug, and one related to erlotinib, small cell lung cancer drug. Third, complex issues like the genus species patents, they were looked at by the Indian courts, and in a large number of cases relating to drugs, the AstraZeneca versus Emcure case relating to ticagrelor, or SI case, the SI cases relating to lorcaserin. They were all cases in which the court agreed that as to the validity of Marcus claims being genus of several millions of molecules, and species would be like selection patents and would therefore be fully justified and not invalid in the face of disclosures made in the genus. The third development was the Bolar exemption provisions, Section 107 of the Patents Act, where a lot of companies started to export drugs to various countries under the garb that these drugs were being exported for generating clinical trial data in those countries. And the court in Bayer versus Alembic and Bayer versus Union of India held that this is not permissible unless the details of who is the importer in the foreign jurisdiction and other details of the quantities being imported, the purpose for which they are being imported, a certification that they are not being imported for commercial purposes, etc. All this needs to be provided, or else that defense of 107A is not permissible. Then the Commercial Courts Act came along, 2016 or so, and after that, the lifespan of litigation dramatically shrunk from a 5 to 10 year period to a 1 to 2 year period, which was such a dramatic change that it was almost revolutionary. And along with that came e-courts, when a lot of the courts in the country that were dealing with intellectual property turned e-courts. All IP matters were deemed to be commercial matters and governed by the commercial courts litigation. Video conferencing was allowed for witnesses who couldn't come into India due to some reason or the other. And there were lots of procedural reforms which accompanied these changes, which effectively reduced the lifespan of litigation and provided a host of newer remedies to the plaintiff and made the intellectual property rights, particularly patents, really, really strong. Then for a moment, let me take from pharmaceuticals, go to standard essential patents in telecom cases and FRAN litigation. And in those, one of the highlights of the past was that confidentiality clubs were allowed in India. And in the confidentiality clubs, the composition was the legal eyes only structure was permitted, which means that if the documents were of a very highly confidential nature, the plaintiff was allowed to restrict them to external lawyers and external experts, but not to the representatives of the defendant. And that was a big achievement to preserve confidentiality. Now, at the IPAB, Intellectual Property Appellate Board, they were dysfunctional for a couple of years, but in the last 3 years, when the correct appointments were made by the government, the IPAB did a phenomenal disposal. Huge amounts of matters were disposed of, and very complex decisions, such as the tofacitinib case of Pfizer, the ibrutinib case of Pharmacyclics, and the ceritinib case of Novartis, which were revocations or post-grant oppositions. They were all disallowed, revocations dismissed, post-grant oppositions dismissed, and the patents held to be valid. And so this was a major achievement of the IPAB when they went into the science in great detail and came up with outstanding decisions. At the patent office level, there was a rise in patent grants from a 5.9% in 2011-2014, right up to 18.9% in 2019. And the government of India also showed a tremendous amount of interest in strengthening patent law by doing things like entering into this patent prosecution highway agreement with JPO, which came into effect during 2020. Now, 2020 onwards, this is where things started to change. And with the pandemic came other ailments as well. So first and foremost, the shock came a few days ago when the government announced that they would abolish the Intellectual Property Appellate Board. And the bill would come up before Parliament as a money bill on the 8th of March. And the question is, will it just pass through the Lok Sabha, the lower house? Will it have to receive, will it have to go to the upper house? Being a financial bill, some people say that it's not necessary. Some people say that the ruling party has votes in both the house and therefore the right numbers. And because of that, the bill would just quickly go through unless the government notices that the IP community is against this bill in a big way. The two reasons given by the government were that the tribunals are costing the government exchequer a lot of money, and so also the IPAB, and IPAB doesn't seem to have done its job. Both those reasons are against the facts, but that's something that we can't discuss in this forum. The second major shock, let's say, were the two decisions in AstraZeneca dapagliflozin cases, where there were a batch of 7 cases decided by one order and a batch of 2 cases decided by a second order, and both the judges refused injunctions to AstraZeneca. 9 appeals have been consolidated, they've been put together and are being heard soon. They're now coming up on the 8th. of this month for disposal. The issues involved, one, whether disclosures in a genus patent need to be, what is the nature of disclosures? Can they be deemed simply because the plaintiff has claimed coverage? And whether post-filing data is permissible, or must all the data to show improvements has to be shown in the patent specification itself? Questions like whether non-disclosure of a terminal disclaimer made in a US application to the Indian Patent Office amounts to a suppression of the kind that violates Section 8 of the Act, and therefore can the patent be held invalid on that ground. These are the kind of issues that are coming up now before the court. Third, there was a recent case of InterDigital versus Xiaomi, where the court said in a request made for a confidentiality club, restricting members only to external lawyers and external experts, the court said it's important for Xiaomi representatives to be part of the club. And again, this is an order which has disturbed many SEP owners, and there are appeals pending. There's one appeal by InterDigital pending in the Supreme Court, and lots of attempts are likely to be made by interveners, including Nokia and perhaps Ericsson, Dolby, Philips, maybe also intervening in some way or the other. On the positive side, we had a wonderful decision called the Ferid Alani case, where there was a lot of discussion by the IPAB on technical effect, and a software or a computer implemented invention was granted a patent. And this would have a far-reaching effect on SEP litigation as well, where patents are challenged under Section 31K of the Act. Another very positive decision was an anti-suit injunction granted in InterDigital versus Xiaomi, where after an initial case in China filed by Xiaomi, within 1 month, a case was brought by InterDigital, who had no knowledge of the details of the Xiaomi action. And then Xiaomi went and filed an anti-suit injunction trying to restrain InterDigital from prosecuting its injunction before the Delhi High Court. And InterDigital then went and got an anti-suit injunction restraining Xiaomi from interfering with the Delhi proceedings. And so that's been granted. It has been argued after the ad interim stage. It's been argued, and now we await the final decision on that as well. The third change which came about is this Form 27 underwent a change. Earlier, if you would file, if you had a genus patent and a species patent and you had claimed that a particular molecule was covered by the genus and disclosed by the species, and you'd file working statements for both the patents, the figures of sales in both would be identical, and the generic companies, as their defenses, would say that this shows that because the working statement shows the same figures, it shows that the genus patent had disclosed the species, and therefore the species patent is bad. And so that argument now will be done away with. Not that it was correct, but even otherwise it wouldn't stand, because the government then reformed Form 27, and if there are related patents, then a single form can be filed for both. The other great change was, after the pandemic, the courts adopted the virtual court culture in a big way. Interim injunctions, final hearings, evidence recordal, mediation, everything started going virtual. The interesting thing is that people became so fond of the virtual environment that now physical courts are reopening from the 15th of March. The Delhi High Court is turning 100% physical, and there's a lot of protest by the lawyers who want either the hybrid system by which physical and virtual can coexist, or the lawyers be left to the choice of going virtual in a specific case. So it's been very interesting how this transformation has taken place and gone a little up and down. And to conclude, therefore, the Quatimate actions still will rule pharmaceutical companies and their enforcement practices, who can file RTI applications before DCGI or before the state regulatory authorities to get information. And if somebody has applied for marketing approval, that would be sufficient ground to file an infringement action. The government recently has been refusing emergency authorizations to certain generics who had tried to disguise their applications and their products as being related to the pandemic. But the government has been careful and has refused these. But it's important to watch out for emergency launches, as some generics have been in the habit of dumping product in the market and then claiming that the product cannot be recalled, even if there's an injunction after 2 months, 3 months, that the large quantity of goods that has gone out in the market has gone on a principal-to-principal basis and therefore cannot be recalled. And that leads to a lot of harm to the market share of the right owner. In the confidentiality club issue, appeals pending in the Supreme Court, those interventions will decide on the 5th, that is day after tomorrow. The matters come up before the Supreme Court, and we will see how the Supreme Court reacts on that. Because of the Ferrer-Delani case, a lot of the computer-implemented invention cases, the validity is likely to be upheld, and that's something very positive. And finally, on the IPAB status, practitioners and associations are now united in opposing abolition. They've given a position paper of several associations saying that this abolition is counterproductive, it will send the wrong signal, and it will take away one of the pillars of IP enforcement from India, and therefore should be recalled. Thank you.
Thank you, Praveen. That was very interesting. We've got Özge back. All right, guys, so we've got some questions from the audience. The first one, Özge, goes to you. Are statements of use required in Turkey?
Yes. So the use of the invention must be proved in 3 years following the publication of the grant, or 4 years after the application is filed, whichever is the latest, let's say. So there is a use requirement, and maybe the opposite may be subject to compulsory licensing. But the system requires declaration of use submitted to the Patent Institute. So if such a declaration is submitted, then the patent is not listed among the patents not used. But this doesn't mean that there will not be any compulsory licensing request. Also, even this declaration, if this declaration is not submitted and the patent is in the list of patents not used, this doesn't mean an automatic compulsory licensing, because there is a court procedure for the grant of compulsory licensing. And during this procedure before the court, the use may be proved before the court at that stage, or justifications for non-use could be argued there. So it is an indication that once the patent is published in the list, it may be open to compulsory licensing, will give a message to third parties that this can be requested, but there's not an automatic consequence, let's say.
Okay.
I think that was all about the question, right?
Yep, that's a very thorough response. Thank you. You've also got the next question. Are there any movements towards implementing an SPC system in Turkey?
No, unfortunately.
No.
This issue has always been on the agenda during EU accession negotiations between the EU and Turkey. So there are a lot of ups and downs in these negotiations, we all know. But unless Turkey becomes a member to the EU, I don't think we can expect an SPC because of no political pressure also in the current environment.
Oh, really? Okay, well, that's interesting.
Yeah,
Good.
I think so.
Okay, so Praveen, the next one goes to you. So you were talking about the IPAB,
Yes.
IPAB. Yes. So we ran a short story on it, I think last week or the week before, where the research we did seemed to show that there weren't judges and it was a very slow moving process. But then you were arguing that lots of people want to keep it. So can you walk us through that? What, the pros and the cons? Why did they want to get rid of it? How likely is this bill to pass, and why should we keep it?
So to start with, you cannot blame the IPAB if the government had not made appointments of technical members. So all the reasons why they were dysfunctional was because the government had not made the correct appointments. But once those appointments of the chairperson and the technical members were made, the IPAB did a phenomenal job. And all practitioners across the board, whether they belong to the pro-patent side or to the anti-patent side, whether they act for the generics or whether they act for the right owners, they all seem to agree that the IPAB did a marvelous job. One. Two, the High Court, of course, is legally extremely sound and capable, but the High Court does not have the technical expertise in a lot of matters. The IPAB, the judge sits along with the technical member, whereas in the IPAB, in the High Court, a judge may have a commerce background and does not have the technical expertise. So it all depends on lawyers like us to demystify a very complex issue before the judge. If we succeed, that's good. If we don't, we fail. So the tendency
of formula is complicated, I'm going to tell you. It's really tough to understand.
A lot of the judges, what they would then do is to wait for the evidence. And so they would postpone the matter till the trial. And so that all obviously means that if the judges in the high courts, the vacancies are not filled up, there's only 40% vacancies filled up in the high court, in the Delhi High Court, there's got to be a lot of backlog in the high courts. So that's why the IPAB should be here to stay, and is contributing to the whole system. So
you think if this bill does pass and it is abolished, that we'll have more of a backlog in India with patent cases?
I think there would be some right owners who believe that the IPAB was mainly responsible for revocations, but those revocations, if they come to the High Court, then the chances are that would favor the right owners, because the patent can only be cancelled or invalidated once the High Court judge gives a finding. And that finding, if it is delayed, then the patent remains on the register. So that helps the right owner. So right owners might favor that. But what right owners would not like is that if their patent is disallowed by the patent office and an appeal has to be preferred, then an IPAB would conclude that appeal much faster and put their patent back on the register than if you were to prefer an appeal to the High Court from the Patent Office, which would take a lot of time to grant that. And so the patent would not be put back. So a rejected patent in the Patent Office would be much better off at the IPAB, whereas a revocation would be much better off at the High Court.
Wow. Okay. In any case, that's a lot of litigation going around. All right. Great. Thank you for that explanation. We've got lots of questions though, so I'm going to try to zip through them so we've got time for everybody. Okay, Özge, this next one's for you. What impact does the current, if any, does the current political situation in Turkey have on the IP system?
Well, the Turkish government gives importance to intellectual property. That's the reason, because this is directly linked and affects the investments. So they acknowledge that. That's the reason why the IP law was revised and a more modern and strong IP law exists right now. But when it comes to enforcement, as I said at the outset of my presentation, the efforts to strengthen the enforcement, the court system is not sufficient, and sometimes you may be suspicious whether certain slowdowns in the system are due to this political impact or not. It's difficult to tell, but the pharma sector is the sector really most influenced by the politics, of course. The health system, pharmaceutical prices. So we see a lot of impact in that area, both in the enforcement and also such as medicines agencies not providing generic applicants information before they sometimes launch or ready to launch. And also we see a lot of difficulties in the enforcement of data exclusivity. Data exclusivity came with the pressure of, again, the EU-Turkey accession negotiations included to the system. But compared to other jurisdictions, there are shortcomings. During data exclusivity term, for example, the generic applications are allowed. So there's a 6-year term, but the originator is deprived of using the 6-year fully. So the generic applications are allowed and processed during this period, this process. So these are clearly political stance of the Turkish government. So I think they're trying to find a balance because the investments are important for Turkey. The geographical presence of the place of Turkey and the patient population brings a lot of opportunities. So sometimes that balance goes on this side to that side, let's say.
All right. Okay. Good to know. Thank you. Next question, back to you, Praveen. I wanted to ask this too. The Confidentiality Club, Xiaomi and Interdigital, what does that mean exactly? Is it just they are not allowed to talk about their case with anyone ever?
No, it's like this. First, if you seek an injunction against a party that violates a patent, if it is a standard essential patent, that is, the patent is relates to a technology which is part of a standard, like a 3G, 4G, 5G standard, then the standard setting organization says you must agree to 2 conditions. Condition 1, you will give a license to whoever wants one, and 2, it must be on fair, reasonable, and non-discriminatory terms, FRAND terms.
FRAND terms.
Now, which means that when you sue someone for violating a standard essential patent, if he's willing to take a license, an injunction will not be granted. But then you have to prove that the terms that you're offering are FRAND terms. To prove that, the courts have said, show the agreements that you have with various parties so that the terms of those agreements or the royalty terms of those agreements can be taken to be accepted by willing parties and therefore taken to be fair, reasonable, and non-discriminatory. Now, when you want to show those agreements to your opponent in court, you don't want the opponent to know the strategies, the market shares, the targets, all the various confidential things contained between the plaintiff and its various licensees. The various licensees also don't want their terms to be shared with an opponent. So you need a confidentiality regime. That confidentiality regime is called a confidentiality club. And there, essentially, the plaintiff and the defendant will both nominate a few members saying, these are the 5 from my side. And the other chap will say, these are the 5 from my side. Those 10 will form the club. And those will then file affidavits in court saying, we will not reveal this information which is disclosed to us to anybody. And so that then you can show freely your agreements to the opponent in the club, and that information will not be revealed to anybody, but the decisions can be taken on whether they are willing to take a license on those terms.
Wait, let me see if I understand this. So you've got two sides, they've both got their guys, they go into the agreement. And let's say you're InterDigital and you've got like a licensee agreement, let's just make it up with Apple. And then Xiaomi's over here and they want to see it. But what about Apple? What if they don't want their contract shown to this group of 10?
That's the reason why. That's the precise reason why InterDigital is saying that you can't have the Xiaomi representatives as a part of the club. That you can have their external lawyers and you can have their external experts, but you can't have their representatives as a part of the club, because my licensee will not agree to that, A, and B, Xiaomi, their representatives will get a disadvantage, will get an advantage, an unfair advantage in their licensing.
Right, because then Apple won't be able to see it. Okay, I mean, that's an interesting solution, but tricky. Yes, Özge?
Yeah, I was just going to say, is this only specific to SEP cases or any similar examples in other
trade secrets? In trade secrecy cases, a lot of parties say, I'm not going to tell you what I'm doing. And then you say, why? It's because it's confidential. So you say, okay, we'll set up a confidentiality regime, a club, and you can then tell to the club members who are limited what you're doing, so that the court can arrive at the conclusion whether you're copying the plaintiff's process or not.
Right.
Just to play King Solomon here, to make it more fair, could you have a confidentiality club of everybody who took that SCP license? So you would have like, I'm just making this up off the top of my head. Could you have like someone from Apple and someone from Xiaomi and someone from InterDigital, and let's make it up from Qualcomm, all form this confidentiality club and just share each other's information, like just their external counsel, and say, we will tell nobody else, and have it like the most elitist Frand dining club in the world? And then I can have my recorder under the table.
I think you're looking for some red wine and some champagne. Are you?
Probably am.
You got the wrong club in your head.
The wrong confidentiality club. Great. All right. Well, thank you. That's really interesting. Our next question actually goes to you as well, Praveen. Do you expect more compulsory licensing in India? I'm guessing this is also the backdrop of the pandemic and everything that's going on, and hunt for vaccines and all that. Do you think you'll see more of it?
It's surprising that in the entire history of patent law in India, we've just had 5 cases of compulsory licenses. Only 5. Okay. We've had Roche and relating to erlotinib, which was filed by NATCO, and that was withdrawn by NATCO when there was evidence of diversion. Then we had Pfizer relating to sunitinib, which was also withdrawn by NATCO. That was a second case. Takeda, a third case. AstraZeneca, a fourth case. And Bayer. And of these 5, Bayer's case was the only case where a compulsory license was granted. 4 were rejected, 1 was granted. And then the government of India went at a seminar, and their representative said, that we do not intend to grant compulsory licenses any longer. Of course, that is not the law. That's only a statement made by the government, because obviously somebody could say, if I move an application for a compulsory license and satisfy the requirements of the law, then I deserve a license. Isn't that right? So, but it just shows the mindset of the government in protecting the rights of IP owners. But otherwise, I don't expect, given the fact that recently somebody had applied for a COVID-related emergency use for a particular medicine, and the government rejected that. It shows again that the government wants to protect foreign companies and their products being taken over by the generics. Yes.
Wow, I just have to say that's really impressive. You knew those off the top of your head, those 5 cases. Well done.
I was involved in 4 of them.
What? Did you have those written down? I was like, did he prep this? I didn't give him this question. Well done. You should teach this. Okay. Next question. Okay, for both of you, beyond Turkey and India, which international IP developments are you following? Is there anything outside of your countries that is?
Yeah, definitely.
Yeah.
For us, we closely follow the EPO case law, as we're EPC members. Any developments there, change in the case law may have some implications. Turkish courts are not bound with the EPO decisions, but we know that the experts give a lot of regard to those decisions. And also UK and German courts practices and the case law. These are the 2 courts that are considered as, providing good services for justice in the patent area. So that's compared to other jurisdictions, when we share a decision from a German or a UK court, it is widely examined or questioned. At least if the court does not agree with such a decision, a good justification is provided. So yes, I can say general EU and UK and Germany.
Okay, EU, UK, and Germany. All right, and Praveen, what about you?
For India, if it is a telecom kind of SEP kind of case, then it's the UK, Germany, USA. If it is a pharmaceutical case, additionally, apart from those countries, also Australia, yes, I would say so. And perhaps Canada, Australia, Canada, yes. If we do have generics coming up with decisions from Korea and Colombia. We have many cases where they come up with decisions where patents have been, similar patents have been invalidated in Colombia and Korea. And we, of course, have to therefore look at those closely, sometimes even China, and of course, distinguish them.
Yeah, we sometimes see generic companies refer to a lot of Indian decisions as well. So it's always interesting to get to know the developments there, especially in compulsory licensing area, the efficiency doctrine, etc. Those are important aspects that generics are widely
you should write to me. I'll send you the cases from the other side.
Okay, from the innovators. Good.
Thanks,
thank you. All right, guys, this has been very interesting and very enlightening. You guys are fountains of knowledge on so many things. I'm going to pass it back to Ed. Ed, if he's there. Hello.
Hi, guys. Thanks very much. Well, yeah, I just want to add as well, thanks very much to the panelists there and to Charlotte for a great discussion. Didn't really expect us to touch on red wine and champagne, but there you go. Anything's possible at International Patent Forum, I think. So we now have our first networking break of the day, just for 20 minutes. After this, there'll be 2 focus sessions, one on FRAND and SEP, practical best practices, and one on strategic considerations for life sciences. So just a reminder, you can click on the session in the schedule that you'd like to watch, and also the other sessions will be available on demand, so you can watch them at a separate time. So we'll see you there at 11:10 GMT, which is in 20 minutes. After those focus sessions, we will have a short lunch break from midday GMT till 12:30, and then we will come back for the next panel discussion. So yeah, once again, I'd like to thank Praveen, Özge, and Charlotte. Great panel discussion, and hope you enjoy the rest of the conference.
Thanks, Ed.
Thank you.
Pleasure to be here.